Hello everyone, welcome back to our channel. In today's video, we are going to explore an essential topic in international trade and finance: legal issues in demand guarantees and standby letters of credit. Understanding the legal landscape is crucial for businesses, banks, and legal professionals dealing with these instruments. We will break down the complexities of legal relationships, governing law, and key disputes that can arise. So, let's dive right in. Every demand guarantee or standby letters of credit involve both commercial relationship and a legal relationship. From a commercial perspective, parties evaluate whether the transaction is beneficial and profitable. However, from legal standpoint, the key questions revolve around right and liabilities, who is responsible for what, and what are the obligations of each party. To fully grasp these concepts, it is essential to understand that every relationship within a demand guarantee structure is separate. The guarantee itself is independent of underlying contract, and the relationship between the applicant and the guarantor is distinct from both the guarantee and the underlying contract. Once a demand guarantee or a standby letter of credit is issued, a legal relationship is established between the issuer or guarantor and the beneficiary. Separately, there is another legal relationship between guarantor and instructing party or applicant as referred in ISP 98. The rights and liabilities in these relationships are governed by three factors. First one, the express terms of the instrument. Second, the applicable rule. And third, the effect of governing law. Legal issues can arise in several ways when dealing with demand guarantees and standby letter of credit. First, disputes may emerge concerning the interpretation or operation of the instrument. For example, a beneficiary might challenge a guarantor's refusal to honor a demand or dispute whether the guarantee has expired. Second, an applicant may seek an injunction to prevent the guarantor from paying a demand or to block the beneficiary from making a demand. Finally, mandatory laws and regulations can sometimes override the express terms of the instrument and the applicable rules, which leads to unexpected legal conflicts. Understanding the distinction between mandatory and non mandatory law is crucial when dealing with demand guarantees. Non mandatory law gives parties the freedom to set the terms of their transaction, choose applicable rules, and make exclusions or amendments. In these cases, the law primarily assists in interpreting agreements and resolving disputes. However, mandatory law can override these agreements. For example, sanction regulations might prevent a bank from honoring a demand even if the presentation complies with the instrument's term. Some jurisdictions also have statutory limitations on the use of demand guarantees, particularly in personal or consumer transactions, which could then lead to reclassification as a suretyship guarantee. The distinction between mandatory and non mandatory law can sometimes be blurred. In Middle Eastern or North American jurisdiction, courts have ruled that a beneficiary holding the original guarantee can still demand payment even after the stated expiry date. This highlights how local legal interpretations can override standard rules in international banking practice. Banks and businesses handling demand guarantees must carefully consider governing law and jurisdiction. Two key questions should always be addressed: which country's law applies to the guarantee, and which court or arbitration body has the power to resolve disputes. A common mistake is assuming that the governing law and jurisdiction of the underlying contract automatically apply to the guarantee. This is incorrect, as demand guarantees are independent of the underlying contract. While parties may choose the same governing law and jurisdiction, this must be an explicit decision rather than an assumption. We know that each country has its own legal system, which can lead to variations in interpretation. Even within the single country, there may be multiple legal systems at play. For example, In the United States, both federal and state laws influence commercial transactions. In the United Kingdom, legal differences exist between England, Scotland, and Northern Ireland. On a broader level, some regions like European Union have established a regional legal framework to harmonize commercial laws across multiple countries. For demand guarantees subject to URDG 758, the governing law is determined by Article 34. If the guarantee does not specify a governing law, it defaults to the law of the location of the guarantor's issuing branch or office. For counter guarantee, applicable law is that of the counter guarantor's issuing office. This structure can sometimes lead to conflicting results, where the law governing the primary guarantee differs from the law governing the counter guarantee, creating legal uncertainty in disputes. If a demand guarantee does not incorporate any rules, identifying the governing law becomes more complex. Some regional conventions, like Rome Convention in EU, attempt to standardize how governing law is determined. However, these conversations can be intricate, leading to costly legal disputes. A practical approach is to look at the place of presentation and payment, but legal advice should always be sought in ambiguous cases. For standby letters of credit subject to ISP 98, the rules do not specify how governing law is determined. Therefore, it is essential to include an explicit governing law clause in the instrument. Without it, the governing law will likely default the place of presentation and payment. But again, this is not an universal rule and should be verified with legal counsel. So, that wrap up our discussion on legal issues in demand guarantees and standby letters of credit. We have explored how legal relationships are structured, common disputes that arise, and the crucial role of governing law and jurisdiction. Whether you are a banker, lawyer, or business professional, understanding these legal intricacies is vital for managing risk and ensuring smooth international transactions. If you found this video helpful, don't forget to like, subscribe, and drop your questions in the comments below. We will be back with more insights into trade finance and banking law. Thanks for watching. See you next time.